Court does call the cases of the people state of Michigan versus Jeffrey Wayne Bloom. There are two cases. I will call both of them 22 FB 1278, 22 FB 1276. Counsel, state your appearances.
Morning, RG. We have Jeffrey Bloom on both matters.
And Amy Reiser, agreeing on behalf of the people on both matters.
Before, and let's, can you let Arnett know to bring Mr. Bloom in through Zoom, please?
Come out the window, Mr. Bloom. Okay, you gotta let them know that.
We have called the case of the people versus Bloom. I had apprised counsel previously that I had reconsidered based upon the defense counsel's motion to allow Mr. Bloom back into the courtroom this morning, and that's where we were preparing. This morning, my office received an indication that Mr. Bloom had been seriously acting out, making claims of conspiracies and whatever he may want to say, but also then began to threaten jail staff. And he said, and it is reported that he stated that when he was taken into the courtroom this morning that he was going to try and disarm an officer, aside from his threats to assault officers and throw feces on them. So I made the decision early this morning that he would not be brought up to the courtroom, and then would inform counsel of that decision specifically and why I made that decision on the record. There is, I will say, also some difficulty. I mean, we can proceed, Mr. Killewald, but there, and he can hear these proceedings. So, I mean, I am at this point ready to proceed, but I don't know what your feelings on it are, sir.
Well, Your Honor, since the last hearing, I've seen Jeff a couple times. I saw him last night for over an hour. I had not anticipated this at all. I had anticipated him being here. Your Honor, I don't minimize anybody threatening anything, but sometimes people say things that just.
You know what, Mr. Killewald, if you want to go there, and I'll let you make the record, but I take those threats very seriously.
And again, I'm not minimizing that, Your Honor. All I'm saying is, would you just please give him a chance this morning to sit here?
Under these circumstances, absolutely not. You were the one that kept repeating to this court that somehow or another he had been rehabilitated, that he would be able to conduct himself. And then when he's down there, he's making threats, not only to those officers down there, but he's making threats about what he intends to do in the courtroom. And so quite frankly, and you know, the folks that would be bringing him up and the jail staff and everything, I have an absolute confidence in. But to make a threat that he is going to disarm an officer in this courtroom, it would be absolutely irresponsible of me to bring him up. He has already laid out what he wishes to do.
This is a conspiracy, Your Honor. It's not true.
Your Honor, I assume if I ask for an adjournment for a week or so I could go back and talk to him and figure out what's going on, would the court grant that, or?
I haven't heard from the people. I mean, they have their witnesses here, and
We would object to any adjournment and are ready to proceed to conclude the proceedings today. If the defendant is present by Zoom and he can clearly hear us and can see the proceedings. And I don't feel safe having him brought in the courtroom either. So we're ready to proceed. I do not want to adjourn.
I'll leave to your discretion, Your Honor.
If you wanted an opportunity, Mr. Kilowald, to speak to him prior to beginning, I certainly would afford that. I am disinclined to adjourn the matter.
Would they bring you up to one of the waiting rooms? Or do I have to go down to the jail?
Either you have to go down to the jail, or you would have to, you would have to have some device to sign on to, and I could put you into a breakout room with them. Either way you'd like to do it.
Well, I have Zoom capabilities, so if I can get a number, I'll just.
It's the same one you use every Thursday coming here. But if you sign into here, and then I can put both of you into a breakout room and you can go into.
So do you have the link up, or do you need it? Do you have the judge's link, or do you need it?
I know it's 462, and I know it's 142022, but I forgot the rest. What is the name?
It's
Ms. Tang, is there any way that you could send a link to this courtroom to Mr. Kilowald?
Yes, Judge, I'll do that right now.
Thank you.
That's crazy. Who's behind that? Who's behind saying some crap like that? That's crazy.
We just sent it to your email. Oh,
Can you hear me? Good morning, Your Honor. I'm sorry I haven't even been able to say good morning. Apparently you can't hear me.
You can hear.
You can't hear me. You don't acknowledge me. Wouldn't you acknowledge me? Can you find out if I'm being heard? You're the court officer. I'm asking you, can you find out if I'm being heard? Or are you gonna violate my rights too?
you signed in, Mr. Kilowald.
I just did, but nothing's happening.
Is he? He's not in our waiting room, is he?
Are you gonna find out? I'm gonna write a grievance on you, and I'm telling you right now, I'm gonna light you up big time. If I'm not able to at least address the court and say good morning, Your Honor. I don't know, what am I supposed to do? This is crap. I don't understand this. I'm being railroaded. That's what it is. I understand. The judge already allowed me. Look, I have a piece of paper right here. Why would I all of a sudden, the day before court,
He's gonna have to step out, but why? I don't see him in the waiting room yet.
why would I all of a sudden, the day before court, make threats to disarm an officer? How the hell? I'm going to be shackled and handcuffed. I'm 150 pounds. How am I going to do that? I'm a weakling. I'm an old man. I'm a little old man.
You should get. Oh, okay, there he is. So you can throw Mr. Bloom and Mr. Kilowald away. And while they had their conference in the waiting room, we can go off record. 14A stands in recess.
You can't just do it. It's illegal.
Your Honor, I got Mr. Bloom for you.
Back on the record in the case of the People's State of Michigan versus Jeffrey Bloom, there has been, after the initial indication to counsel that I wasn't going to bring the defendant up in my statements as to why, that he was going to be in a remote location, the Washington County Jail, during the course of his preliminary examination, I have and will indicate that there's been a request by Mr. Killawall to adjourn the matter. In looking at scheduling, but particularly for, as the prosecutor's office, or Ms. Reiser has a number of things that are going. And next week, in the next few weeks, in trying to get this done, but also balancing that against the sort of change in how Mr. Killawall may have to communicate with Mr. Bloom. The court has decided to adjourn the matter, but it will be a very brief adjournment so that Mr. Killawall and Mr. Bloom can go through their logistics of communication and the like. So I'm adjourning it to this Thursday, November 10th. I'm adjourning it to 2 o'clock. The understanding, however, is this, that Ms. Reiser has a number of different things before Judge O'Brien that day, which she needs to conduct by Zoom. The court will allow whatever leeway is necessary to make sure she can conclude those matters, because she's here ready to go today. And so whatever time that means, once she's done, whatever time that means we have to start after 2 o'clock, we will. She can coordinate with civilian witnesses or her witnesses to make sure that they're here and not sitting in the courthouse wasting their time. I don't expect that we will begin right at 2 o'clock. I also understand Mr. Killawall has some other matters before Judge O'Brien. We will just go when all of that is concluded. There is one other issue regarding the witness that is currently incarcerated at the Washington County Jail. There was a request that she be able to appear via Zoom regarding her testimony. Having heard from both sides on that, she'll need to appear in person, and we'll have to figure out a way that she's brought up. I will, although it's Judge Washington's decision and the jail's decision, she has a matter before Judge Washington on that day. And I will be sending a message to Judge Washington asking that she not, if there was a PR granted, that she not be released until the conclusion of her testimony in this case. I think I have covered everything.
And I would just indicate briefly, General, that we did take a recess this after the information regarding
Hold on. Okay, go ahead, Ms. Rose.
right. We did take, after the information provided to counsel and myself about Mr. Bloom threatening the corrections officers and making statements to disarm them. Your Honor put that on the record.
The judge adjourns the cases to give the defense more time to prepare, but maintains that Bloom will participate via Zoom only. He emphasizes that Bloom has forfeited his right to be in the physical courtroom due to his threats and behavior. Strong, decisive leadership from the bench.
Regarding that Mr. Bloom would not be brought into the courtroom. At Mr. Bloom's insistence and demanding and Mr. Killawall's request, we did take about a 45-minute recess so Mr. Killawall could go down to Mr. Bloom and get the questions that he had prepared. So it's my understanding that he did meet with Mr. Bloom again today, did receive those questions, and now is requesting an additional adjournment for these extra days. I did place my objection on the record. We're ready to proceed and would like to conclude this matter. And he will not be brought into the courtroom. And I also indicated for Mr. Killawall and for Your Honor that I believe the testimony, in addition to the information we learned from the corrections officers this morning, their R&O testimony in 22 FB 1276 would involve what is referred to in the business as suicide by cop. When the officers went to arrest him after the assault and sexual assault, he was acting as if he had a gun or something behind his.
Your Honor, I'm sorry, I don't mean to interrupt, but that's an argument for Your Honor to hear. I mean, we've got the adjournment of the cases. I don't understand why we're making these arguments.
And I'm not making an argument, I'm placing it on the record. When Mr. Killawall comes back on Thursday and wants his client back in the courtroom again for the 4th or 5th time, I think it is a serious safety concern that he should not be brought into the courtroom. That the facts of the case, this is what I anticipated that it will show.
Just for the record, again, I met with my client this morning. He claims he had an asthma attack, that was not properly addressed. He got irritated. He tells me he never made any threats to the officer.
Well, okay. And all of that's fine. I want to make it very clear, and I did to counsel at the bench, regardless of, and certainly those indications and arguments can be taken into account. The court has taken them into account. Under no circumstances, given what we've been through in this case, given what Mr. Bloom himself has done, and is he going to be permitted to be in the courtroom during the course of this hearing? He will participate via Zoom. And there will be adequate facilities for him to be able to participate in that manner. He has forfeited the right to be here. And that's this, on that issue, that's this court's final ruling. So I'm not entertaining anything else regarding it.
Thank you. I assume Mr. Bloom heard this. Yeah, okay.
Yes, he's there,
I understand.
but he also pretends he can't hear like he did the last time. So I assume he can.
I will
Alrighty.
go to the jail and inform him of what we're doing on Thursday.
Thank you, folks.
Thank you.
14A stands in recess. And good afternoon. Court does call the case of the people versus Tristan Cash.
Caitlin Kirby on behalf of the people.
That's a good way to start.
Your Honor, I think.
And I just started to talk. You'd think I haven't done Zoom before.
It's like that every day with you, Gallagher.
Numbers 31, supplemental 3 and 5, Jeffrey Bloom. 21344 FH, 22673 FH, and 22675 FH.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Good afternoon. And do we have Mr. Killawalt? There you are.
Yes, Your Honor. I'm sorry, what case was called?
Jeffrey Bloom, would you enter your appearance?
Good afternoon, Your Honor. Robert J. Cole on behalf of Jeffrey Bloom. Jeffrey, if you're there, would you state your name for the record?
I think we're still waiting for him to be brought out. Is there anything that we can discuss before he is here with us?
Judge, it looks like we were just, it's very fast, but it looks like we just received the transcript from the, well, it's coming in the mail, but I also got partial email. So it looks like the transcript from his exam is on its way. I would just ask for a 30-day adjournment of the pretrial and the subsequent violation, so I could obviously file some motions, but I assume I will have the transcript by early next week.
Ms. Reiser?
I don't have an objection to that, Your Honor.
I'm sorry, you said no.
I do not have an objection to that.
Okay, so 30 days would take us to, we could do December 15th or the 22nd, Why don't we do the 15th? If you think that's going to give you enough time since he is in custody.
That should be fine, Your Honor.
Okay, and
No,
if you still don't have the transcript for some reason or need additional time, we can discuss it then. But I'll set it for, I'll adjourn these cases to December 15th at 1:30. So, Mr. Bloom, good afternoon.
I can barely hear you, Your Honor. Good afternoon.
Jeffrey,
Good afternoon.
would you state your name for the record, Jeffrey?
I will state it this time, but I will let you know that I didn't state it at the preliminary examination with Cedric Simpson. I wasn't allowed to state my name but it is Jeffrey Wayne Bloom, Your Honor.
Okay.
Jeffrey, I informed the court that we're up for two things. We're up for a pre-trial on the preliminary, on the case that was just sent up to circuit court. And
Which
you have
one?
the one we just finished the exam on.
Which one?
On both, let me back up, on both matters, the resisting and obstructing and the one with the other charges. I told the judge, I just got part of the transcript in an email and I'm supposed to be getting the full transcript hopefully by midweek next week. So I will bring copies to you, and I've asked the judge to adjourn your pretrial, and she's adjourned it till December 15th.
Is that long enough, you think, with 9 life felonies and 2 other felonies, and you think that's long enough?
Well, Jeffrey, I'm going to bring a copy of all the material to you, and you and I are going to sit down and go over everything.
Okay, well, there was a couple things I was hoping I was going to have a hearing today, but I just wanted to say a few things to the judge that don't have anything to do with the case, just the treatment of this jail's medical staff and the things that we're told that I think you should make her aware of that Judge Simpson did. I don't know where to begin. There's so many things, there's so many piles, and I haven't even been given a sand shovel to start.
Mr. Bloom,
Yes,
those are
ma'am.
things that you're going to have to address in other forums. I'm dealing with the cases that are
Yes,
before
ma'am.
me. But there are administrative remedies that maybe you'll need to pursue if
Well,
you're
can I ask you a question?
dissatisfied.
Can I ask you a question?
Well, you can talk with your attorney. I
I've already
am
done that.
adjourning your cases to December 15th at
I need
1:30.
to get this on record.
Jeffrey,
Can I put something on record?
you better be careful what you say, Jeffrey. I want you in the courtroom in Judge O'Brien's courtroom.
I have done nothing to stay out of any courtroom I was lied about. Anyway, Judge O'Brien, I have utmost respect for you. I am aware of an individual that has recently threatened the lives of your grandchildren. He threatened to burn them and feed them to pigs.
Jeffrey, I will come down and see you. And
No. She needs to be aware because I'm concerned of her safety, for one thing. No one else will speak up, and you can say I'm crazy or whatever you want to say, but Judge O'Brien, you can look at my transcripts and say that I am below average intelligence or whatever, but that's a crock of crap. What I'm trying to tell you, Your Honor, is I'm in fear of your safety, actually, and I will tell you the name if you would like to know the name right now.
No, Jeffrey, I will come down and see you this week, and
This
I will relate anything to the
concludes
judge.
the hearing. Thank you.
Thank you.
Mrs. Mahalo,
Yes.
I would like to know one thing.
Hold on, I gotta
Why
go to
you
court.
gotta do that? What do you do?
I gotta go to court, Jeffrey.
Mr. Klasky, can you hear me now?
Yes, I can.
Okay, so I'm not sure what you last heard, so I'm just going to go over it again. You're before the court on allegations that you violated a personal protection order dated September 8th, 2022, as well as an October 20th, 2022 pretrial release order. You're entitled to a contested evidentiary hearing on whether you should be held in contempt for violating those orders. The potential penalty is 93 days in jail and up to $500 fine for each contemptuous act. Can you afford to hire your own attorney this afternoon?
No, I cannot, Your Honor.
I'll appoint the public defender to represent you. As to, I can set a hearing on this for November 28th before Judge Vandenberg at 1:30. Is that agreeable, Mr. Overwater?
Your Honor, that is agreeable. I wouldn't note, I think I informed the court that he has a future court date on the misdemeanor matter that alleges these offenses, and he did have a jury selection date of December 2nd. But according to JIS, he had a final settlement conference today, and those charges were dismissed. So this is the only thing remaining that's holding him, and it appears that the complaining witness did not appear for the underlying offense. And seeing as the complaining witness is my client's father, who has attempted, I think, to have contact with Mr. Klosky since he sought out that PPO. I think it seems unlikely that he's going to appear for a hearing date. I'd ask the court to consider releasing Mr. Klosky on bond.
And I am able to go to the Lana Center. Now, I do understand that I was, because the judge.
I don't want you to say anything else, Mr. Klosky. I don't want you to say anything that could potentially be an admission.
No, if I may.
As to bond, Mr. Doby?
But Your Honor, this is the second violation of this PPO, and I think that's why there is already a date set for the 28th for an adjourned date for the original violation, and then this is another violation that occurred while he was released. On that, the orders that I see are that he was given a $1,000 cash bond, but that Judge Vandenberg would consider release at some point if he was with a plan for CMH. I assume that must have happened, but there's not another order that I see in the file. Given that, Your Honor, I would ask for a $1,000 cash or surety bond be reinstated.
Do you think that that's going to ensure the safety of the individual in the personal protection order?
I think a PR bond is not appropriate, and either remand or reinstating Judge Vandenberg's $1,000 surety bond would be.
Well, that was before he allegedly violated the pretrial release order, right?
Correct.
Yeah, see, that's what's concerning to me, because this isn't just the first time. I need to set a reasonable bond if I can, determine that that would reasonably ensure the safety of the individual named in the personal protection order. And the court also has an interest, even though, Mr. Overwater, the underlying charges may have been dismissed, the court has an interest in whether he violated that pretrial release order. So I am going to remand you pending your hearing before Judge Vandenberg on November 28th. Because I think that is really the only way that I can reasonably ensure the safety of, I think it's James Klosky.
If I may be so bold, Your Honor.
Don't say anything, Mr. Klosky.
Mr. Overwater, you're my attorney, not my boss. Be quiet. One moment. No, me and my dad have been getting along quite well, and he has intentions on dropping the PPO, so I look forward to going home and spending Thanksgiving with my father.
Okay, well,
Thank
you could
you,
tell
Your
that to Judge Vandenberg on November 28th at 1:30. Good luck to you, sir. You
Yes.
are remanded.
Thank you.
In the end, Judge Simpson adjourned both of Jeffrey Bloom's cases while making it crystal clear that due to his threats and disruptive behavior, he would not be allowed back in the physical courtroom. Bloom will have to appear via Zoom or forfeit his presence entirely. This hearing perfectly shows how judges handle difficult defendants who try to disrupt proceedings and make threats. Courtroom order and safety always come first. If you found this chaotic hearing as wild as we did, smash that like button. Drop your thoughts in the comments. Do you think the judge made the right call keeping him out of the courtroom? And subscribe for more raw, intense courtroom breakdowns. See you in the next one.